1. We can begin.
The subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. Good morning and welcome to today's hearing, the fourth in the subcommittee's series focused on the development of legislative proposals to strengthen and modernize the antitrust laws. This hearing is an opportunity to examine the state of competition in labor markets, as well as ways to promote the economic opportunity of hardworking Americans through robust enforcement of our antitrust laws. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I now recognize myself for an opening statement. Across the political spectrum, Americans know that the economy is not working for them. They feel it in every paycheck, every surprise medical bill, and every credit card payment. Nobel laureate Joseph Stiglitz described this as, and I quote, a widespread sense of powerlessness, both in our economic and political life. We seem no longer to control our own destinies, end quote. That is because waves of consolidation in recent decades have led to the rise of market power among employers, decimating jobs and wages, and rigging the economy against the American worker, independent businesses, and entrepreneurs. In the midst of this trend, corporations are earning monopoly profits that are not being reinvested in higher wages or our economy, threatening the financial security of working people. As Professor Iona Marinescu testified last Congress, the economic concentration of labor markets across the country has given employers market power over their workers. Employers with market power, also called monopsonists, have the incentive and ability to pay lower wages than they would in a competitive market. It is nearly impossible to overstate how harmful this is to the American worker. In the absence of competition, employers have virtually no incentive to pay fair wages to retain workers or attract new talent, and workers are trapped in low-paying jobs. Many workers are unable to escape low-paying jobs or find new jobs after being laid off simply because there are fewer alternatives than would exist in a competitive marketplace. And as Professor Eric Posner will testify today, because employers push down wages by hiring fewer workers, fewer people end up working. That means that there is less output, which ultimately results in higher prices for consumers as well. While the effects of economic concentration have been devastating for nearly all workers, it most severely harms workers in vulnerable groups such as women and people of color who have less bargaining power against wage discrimination and other forms of workplace inequality. This economic catastrophe has been compounded by the ubiquitous presence of non-compete or no-poach agreements in employment contracts. As Professor Evan Starr testified last Congress, these restraints have become, and I quote, so pervasive that even volunteers and nonprofit organizations in states that do not even enforce them are asked to sign away their post-employment freedom, end quote. Unfortunately, these trends have only worsened in the wake of the pandemic. Last year, despite record levels of unemployment, employers continued to go to court to enforce non-compete clauses that prevented workers that they had laid off from taking new positions. For example, as Bloomberg Law reported, in Pennsylvania, a sports retailer laid off a salesman who had worked there for 31 years and then tried to keep him and other sales staff from taking new positions. A medical provider sued to keep a Houston doctor from opening new offices. This, of course, is bad for business. From engineers to healthcare workers, the presence of non-compete clauses in employment contracts has undoubtedly contributed to labor shortages that have weakened America's economic recovery from the pandemic. There's also no shortage of examples of collusion among employers to fix wages or agree not to hire workers at competing firms. Even though these restraints are criminally illegal, no-poach clauses appear in everyday employment contracts, including nearly 60% of agreements among major franchises in the United States, driving down wages and preventing workers from moving to better job opportunities. Finally, nearly a third of jobs require licensure, including many jobs that have little impact on public health or consumer safety. Although there are many benefits associated with establishing credentials for professions, particularly those with important public health and safety considerations, excessive licensing can create barriers to entry in the workplace, impose additional costs on workers, and result in job losses. Moreover, because these standards differ by state, licensing barriers can disproportionately harm military families, which are 10 times more likely to relocate across state lines than other working families. As the late economist Alan Kruger has explained, and I quote, the most common jobs for military spouses are nurses and teachers who often have to get licensed in the new state when they move, pay a licensing fee, and by the time they are permitted to work in those states, they often move again, end quote. Although some states have eased the burdens on healthcare workers through interstate compacts, This continues to be a problem today. In recent years, antitrust enforcers under both Republican and Democratic leadership have begun paying more attention to the effects of economic concentration on labor and producers. Under the Obama administration, the antitrust agencies issued joint guidelines clarifying that no poach agreements and wage fixing can be criminally prosecuted. This important work continued under the prior administration and continues to be a priority under the Biden administration. In July, President Biden issued Executive Order 14036, which outlines a pro-worker, anti-monopoly agenda for the 21st century. As the order states, excessive market concentration threatens the economic welfare of workers, while a competitive marketplace creates more high-quality jobs and the economic freedom to switch jobs or negotiate a higher wage. Earlier this month, Vanita Gupta, the Associate Attorney General of the Justice Department, said that the Antitrust Division will make ending collusion among employers a top priority. As she said, and I quote, "American workers who are struggling to make ends meet may not always be able to stand up to their employer, but the department can and will," end quote. But Congress also has an important role to play. Although more vigorous enforcement and competition rulemaking can address some of the concerns, the antitrust agencies cannot change the law on their own. Moreover, in recent years, courts have shown hostility to bold enforcement activity in this area in the absence of legislative guidance. As Professor Posner will testify today, legislation that more clearly laid out the elements of labor-side antitrust claims would help push the courts in a positive direction. As I've said before, I firmly believe that we must explore every path for creating economic opportunity for all working Americans as we build back better. This must be a national priority. With that in mind, today's hearing is an opportunity to examine these concerns and explore potential legislative solutions. I look forward to hearing testimony from our esteemed panel of witnesses on these matters, as well as potential paths forward for fixing these problems. I now recognize the distinguished gentleman from Colorado, the ranking member of the Antitrust Subcommittee, Mr. Buck, for his opening statement.
I thank the chair, and I have to admit to the chair that I'm a little baffled by this hearing. I'm not sure what specific legislation we're going to take up today or in the future based on the opening statements and the nature of this hearing. Certainly, those of us on this side of the aisle have done our best to work with the chair and others on this committee when it comes to big tech and when it comes to reforms in the pharmaceutical industry, but this, frankly, is baffling to me. We do know that the Biden administration has taken a number of steps that have hurt workers in the economy. For example, we've learned through the Obama administration and the really measly economic growth that occurred during the Obama administration that if you offer individuals unemployment benefits and they can stay home and make a living off of unemployment benefits and other benefits, they won't go into the workplace. And we've seen that. We saw also that when we have millions upon millions of illegal immigrants in this country and they are driving down wages for all American workers, it is significant. And when we look at what's happening on the border with the Biden administration, we see an open border. We see really a sad situation, humanitarian situation, where we are inviting people into this country by sending all the wrong signals, and we have, as a result, this crisis. We have a border patrol that's overwhelmed. We have a country that is now accepting tens of thousands, if not hundreds of thousands of people into our country on top of the millions who are already here illegally. We don't deal with an immigration issue. We don't deal with the unemployment benefits and the effect on our economy. We also saw from the Trump administration that if we really want to raise workers' wages and we want to help our economy, we'd lower taxes. And this week, we may very well be taking a step towards raising corporate taxes, raising other taxes. When we lowered taxes, what we saw was a significant investment from overseas coming into this country, and even companies and individuals in this country that had their money on the sidelines were willing to invest that money because there was a climate and an optimism about our economy that doesn't exist anymore. We also saw the Trump administration reduce regulations significantly. We saw at one point in time there were 27 regulations repealed for every one new regulation that was enacted The Biden administration is going the exact opposite direction, and we're seeing the effects of that on our economy. We also know that it's important to have strong trade agreements, and those trade agreements lift American workers' wages and create a robust economy. And the disastrous surrender, not withdrawal, but surrender from Afghanistan has put the U.S. in a situation where we are weak, or we are perceived as being weak by our allies and frankly, our adversaries also. And so the idea that we will strengthen workers' positions with non-compete agreements or changing the nature of non-compete agreements or tinkering around the edges of antitrust is laughable when you look at how far this administration has gone in the wrong direction. And last, but certainly not least, by spending the trillions of dollars, $6 trillion on COVID alone, what we see is inflation. And if there's one thing that eats away at workers' ability to improve their lot in life, it's inflation. And we see inflation, it's going to be with us, and it's going to be part of the new reality of this Biden economy. And I think it's terribly sad. I have faith that the chairman is holding this hearing in good faith and wants to accomplish some worthy goals, but I really think that our time would be much better spent battling against the $1.2 trillion infrastructure bill, the $3.5 trillion reconciliation bill, dealing with the immigration crisis at our border, talking about how we need to get people back to work and stop giving them unemployment benefits. I think we have to make sure that we lower taxes, not raise taxes, that we reduce regulations, and that we do everything we can to improve our trade agreements. And with that, Mr. Chairman, I yield back.
I thank the gentleman for yielding back. And before I recognize our next witness, I should have done this at the beginning, but I would remind everyone, following the current guidance of the Office of the Attending Physician, it is this committee's policy that members and staff in the room wear face coverings at all times, except when they've been recognized to speak. And I now recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, as we all well know, America's economy has become highly concentrated in recent decades. A small number of firms dominate a variety of markets that Americans rely on, including pharmaceuticals, airlines, broadband, online platforms, and meatpacking. Just as consolidation in product markets tends to result in higher prices and lower quality in the goods we buy, consolidation has also led to high levels of concentration in labor markets. As in any other market, when a lack of competition gives employers excessive power over workers, employers have the incentives and ability to abuse that power. In many industries, these dynamics have led to depressed wages and opportunity, limited worker mobility, misclassification of workers, and discrimination against the most vulnerable. Employers with market power can abuse their power over workers in several ways. Some have imposed anti-competitive terms in employment contracts, such as non-compete agreements that ban workers from finding a better job or starting a competing firm. Others collude with rivals to fix wages or prevent workers from changing jobs. With the rise of the gig economy, we see a rising number of employers misclassifying employees as independent contractors. These practices harm workers. They exacerbate wealth inequality. They frustrate the ability of workers to earn a living wage and to support their families. These practices have no place in a free and fair economy. For decades, the antitrust agencies have been too weak or too timid to vigorously enforce the antitrust laws to stop and deter abuses across the economy. But as Professor Eric Posner will testify today, these trends have been worse in labor markets, where enforcement has been virtually non-existent until very recently. These failures have undermined economic opportunity and the financial security of American families and small businesses. And in the wake of the pandemic, the impacts of these developments have hit our frontline workers the hardest. Healthcare workers, delivery drivers, grocery workers, meat packers, and other frontline workers have been heroes, keeping us safe, helping American families put food on the table, and keeping our economy going under the most challenging of circumstances. Unfortunately, where these workers have saved us during the pandemic, all too often our society has failed them. Many of these workers, who in many industries are overwhelmingly women or people of color, often work for wages that are too low and in conditions that are unsafe. And in many cases, they are stuck working for corporations that have cornered the market, undermining their ability to find better jobs or higher wages in their field because they simply do not exist. For example, as Ms. Payton will testify today, consolidation in the hospital and physician market in Western Pennsylvania has led to lower wages and fewer choices for employment. As she notes, there is almost nowhere else to work if you are a healthcare worker. Moreover, as other witnesses will testify today, many of these workers are subject to anti-competitive restraints on their mobility, such as non-compete and no-poach agreements. These abusive contracting practices have become ubiquitous in the workforce, further entrenching the power of employers over workers and preventing the unemployed from getting a new job. This must change. And I am encouraged by recent steps by the Biden administration to address this problem meaningfully through all available tools. In July, President Biden issued Executive Order 14036, a sweeping and historic approach to building an economy that works for everyone through the benefits of competition. As this order states, quote, consolidation has increased the power of corporate employers, making it harder for workers to bargain for higher wages and better working conditions, close quote. In response to this concern, the President's order encourages the antitrust agencies to undertake a series of actions that will protect workers and promote competition in labor markets. These include adopting rules to curtail the use of non-compete and other agreements that unfairly limit worker mobility, as well as policing collusive behavior among employers, such as wage fixing. This is a critical effort, and I look forward to updates from the Federal Trade Commission and the Antitrust Division at the Department of Justice on their work to combat market concentration and abuses of market power that harm workers. Congressional action is also necessary. There is a pressing need to update the antitrust laws to ensure the antitrust agencies have the necessary tools to stop and deter anti-competitive conduct and mergers that harm workers. As I've said before, it will also take a comprehensive set of reforms to recover economic opportunity and dignity for working people. These problems must be addressed with lasting solutions, like guaranteeing equal pay for equal work, prohibiting forced arbitration agreements and employment contracts, establishing a living wage, stopping worker misclassification, and strengthening unions. But legislation that will revive competition in labor markets competition is a critical part of this agenda. I want to thank all of our witnesses for testifying this morning. I especially want to thank Ms. Payton and Mr. Gross for appearing today and for sharing their testimony. We appreciate that, working in the healthcare and the logistics and delivery industries, you have been on the front lines during the COVID-19 pandemic. Without you and workers in other frontline professions, our economy and our society cannot function. So I thank you. I also thank the chairman for holding today's hearing on this very important topic. And with that, I yield back the balance of my time.
I thank the gentleman, and I now recognize the ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Before President Biden, before Democrats controlled all of government, there was never a better time for American workers. Manufacturing was on the rise. According to one estimate, President Trump's first 30 months, manufacturing jobs were up 314,000 over where they were under President Obama. We had low unemployment, in fact, the lowest in 50 years. Wages were booming across the board, and we saw massive job growth across all sectors of our economy. Anyone paying attention knows that even with the virus, our job market is resilient. Drive through any town in America, anywhere, and you will see dozens of hiring signs, with many offering high starting wages and signing bonuses. Talk to any employer right now, and their biggest problem is actually getting people to come to work. So the biggest threat to the American worker is not any of the things you brought up in your opening statement. Frankly, the biggest threats to the American workers are far-left Democrat policies. Democrats are using the pandemic to have a government take over our economy. They want to make permanent the extraordinary welfare programs enacted in the last 18 months. And on top of that, they want to ram through trillions of dollars more in spending. We've seen an eviction moratorium, vaccine mandates, paying people not to work, not to mention higher taxes, rampant inflation, and undoing much of the Trump administration's regulatory reform. I mean, the Democrats' economic plan seems to be lock down the economy, spend like crazy, pay people not to work, tell them they can't be evicted, and then for everyone who is working and is paying their rent, oh, they're going to raise your taxes. Such a deal. Maybe the dumbest economic plan I've ever heard of, but that's their plan. Make no mistake, the Biden economy is not helping American workers unless these workers are federal bureaucrats in Washington. The radical Democrat policies are leading to higher prices for American consumers in the short run, and in the long run, they will only increase the already crushing debt burden we're placing on our children and grandchildren. And that's not even to mention some of what Democrats on this committee have proposed doing, including empowering the Biden administration's radical Federal Trade Commission to attack our free enterprise system by overhauling antitrust laws and upsetting precedent that applies to the economy as a whole. If you thought corporate America was in bad shape now, just wait until Lena Khan and other Biden bureaucrats get more power. The chair of the FTC is already abusing the power she does have and is ruling the FTC in an authoritarian fashion in a total departure from the way the commission has worked for the last half century. In fact, I look forward to hearing from Commissioner Wilson on some of these concerns. This committee ought to be conducting far more oversight of the FTC and how it has moved away from its original mission. The best thing we can do for the American worker is getting Washington off their back. I look forward to today's discussion, and I want to thank all our witnesses for being here today. Mr. Chairman, I yield back.
The gentleman yields back. It's now my pleasure to introduce today's witnesses. Our first witness is Eric Posner, the Kirkland and Ellis Distinguished Service Professor of Law and the Arthur and Esther Kane Research Chair at the University of Chicago Law School. He's been a member of the faculty at the University of Chicago since 1998. Before teaching in Chicago, Professor Posner spent 5 years as a professor of law at the University of Pennsylvania and 1 year as an attorney advisor at the Department of Justice's Office of Legal Counsel. He's written a number of highly regarded books, including Law and Social Norms and How Antitrust Failed Workers. Professor Posner is a fellow at the American Academy of Arts and Sciences and a member of the American Law Institute. Mr. Posner received his bachelor's and master's degree from Yale University and his JD from Harvard Law School. Today's second witness is Brian Kalaki, the chief economist at Open Markets Institute. He's a leading expert on workers' rights issues and has served as senior research analyst for both the Service Employees International Union and the Change to Win Strategic Organizing Center, as well as a consultant for the Communication Workers of America. Additionally, Dr. Kalaki has extensive experience as a union leader, having held multiple leadership posts with the Graduate Employee Organization and the Washington-Baltimore Newspaper Guild. His work has been featured in journals including the Journal of Law and Political Economy and the Labor Studies Journal. Dr. Kalaki received his bachelor's degree from Franklin and Marshall College and both his master's and PhD from the University of Massachusetts Amherst. Our third witness, Dan Gross, is a feeder driver at the United Parcel Service and a member of Teamsters Local 177 in New Jersey. Mr. Gross has been an active union member since he began his employment at UPS 22 years ago. Mr. Gross knows firsthand how important collective bargaining, direct action, and organization are to the American worker. Because of his membership in the Teamsters, Mr. Gross has been able to build a career with an upward trajectory at UPS and to earn a stable living. Mr. Gross is a prominent leader in his union community, serving as a shop steward for Local 177. Our fourth witness is Nyla Payton, a medical administrative assistant at the University of Pittsburgh Medical Center. She has worked at UPMC for almost 16 years and is the primary breadwinner for her family. Since 2015, Ms. Payton has been a vocal advocate for improved pay and benefits, expanding workers' rights, and unionization at UPMC. She helped to organize Hospital Workers Rising, an organization of hospital workers in Western Pennsylvania dedicated to improving their working conditions. Ms. Payton has spoken at multiple rallies and panels, submitted testimony to her wage review board, and organized her colleagues to build support for forming a union at the medical center. In 2017, she was included on the Incline's Who's Next list of community leaders and activists working to build a better Pittsburgh. Our fifth witness, the Honorable Christine Wilson, is a commissioner at the Federal Trade Commission. She was sworn in by former President Donald Trump in 2018. Before her nomination to the FTC, Commissioner Wilson served as the Senior Vice President, Legal, Regulatory, International at Delta Airlines. She also practiced antitrust law at Kirkland & Ellis, LLP, and Mulvaney and Myers, LLP. During the Bush administration, Commissioner Wilson served as the FTC as chairman, Tim Mercer's chief of staff. Commissioner Wilson received her bachelor's degree from the University of Florida and her JD from the Georgetown University Law Center. Today's last witness, Bruce Kobayashi, is the Page V. and Henry N. Butler Chair in Law and Economics at George Mason University's Antonin Scalia Law School. Most recently, Professor Kobayashi served as the director of the Federal Trade Commission's Bureau of Economics. Additionally, he has worked as an economist with the FTC, a senior research associate with the United States Sentencing Commission, and an economist at the Department of Justice. He is widely published with works appearing in highly regarded publications, including Competition Policy International and the Journal of Competition Law and Economics. Professor Kobayashi received his bachelor's and master's degrees, as well as his PhD at the University of California, Los Angeles. We welcome all of our distinguished witnesses, and we thank them for their participation. And I will begin by swearing in our witnesses. I would ask our witnesses testifying in person to rise, and ask our witnesses testifying remotely to turn on their audio and make sure that I can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and accurate to the best of your knowledge, information, and belief, so help you God?
I do.
I do.
Let the record show the witnesses answered in the affirmative. Thank you, and you may be seated. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there's a timing light in WebEx. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes have expired. I now recognize Professor Posner for 5 minutes.
Thank you, Mr. Chairman, and it is truly an honor to be invited to speak to you. I'm sorry not to be there in person. Unfortunately, for pandemic-related reasons, I was asked to stay here, although I'm perfectly fine. As you mentioned, I recently published a book called How Antitrust Failed Workers. The book is the result of several years of research into this topic, and I'll spend a couple minutes telling you what I found. Let's start with a simple example, which I'm sure other people will talk about as well. Imagine that we have in a small town two hospitals, and the hospitals would like to merge. Now, traditionally, if the hospitals want to merge, they may need to obtain the consent of the government, the FTC or the DOJ. And the FTC and DOJ will look at whether the merger would have negative effects on what's called the product market, that is, the price and quantity of medical services to the surrounding population. If the two hospitals are very large, they may well try to block the merger. The merger would be illegal because it would predictably raise prices and reduce medical services. What the government agencies have virtually never done, I guess literally never done, is look and see whether the merger might have negative effects on labor markets. If two hospitals merge, they employ most of the nurses and doctors, medical technicians, and other specialists in the area. Then according to economic theory, if the hospitals are very large, one would expect the merger to result in lower wages, less employment of the professionals, less output, and so ultimately higher prices. Labor market-oriented anti-competitive behavior is just as bad as product market-oriented anti-competitive behavior. It's also a violation of the antitrust laws. And I'm not just talking about mergers, I'm talking about conventional forms of collusion. There's price fixing on the product market side, wage fixing on the labor market side. There are market divisions on the product market side. There are no poaching agreements on the labor market side. These are all equally harmful types of conduct, harmful for workers, harmful for consumers. And of course, workers and consumers are the same people. Now, antitrust law, just as it is on the books and as it has been recognized by the courts, applies in the same way to labor markets as it does to product markets. And yet, and this is what my book is about, there have been virtually no labor market cases. There have been a handful in this country. There have been no merger reviews that resulted in a merger being blocked because of the labor market effects. In fact, there's been virtually no consideration at all of the labor market effects of mergers. Similarly, there's been very, very little antitrust litigation that deals with no poaching agreements, wage fixing agreements, covenants not to compete, and other forms of anti-competitive behavior by employers. And there are literally zero cases involving true monopsonists, where you have a very large employer who uses its monopsony power, its market power over the labor market to suppress wages, to prevent competition. And this is a puzzle, given that the law applies equally. And the puzzle is not easily answered. This probably is the result of certain historical traditions, including the primary responsibility of unions to protect workers. Of course, union density has declined significantly over the last 50 years, so they're no longer able to do that to the same extent as they did in the past. The explanation for this difference, what I call a litigation gap between antitrust litigation focused on product markets and antitrust litigation focused on labor markets, does not have anything to do with market structure. This is the significance of the research by Ioana Marinescu and her colleagues, and by now dozens and dozens of labor economists, and who have found with complete consistency that labor markets in this country are extremely highly concentrated. And other economists have found that anti-competitive arrangements like non-competes and no poaching agreements are extremely common. So there does seem to be a problem with labor markets that antitrust laws should be used to address. And yet, until very recently, this has not been done. The FTC, to its credit, by the way, during the Trump administration, issued a public comment to a merger in Abilene, Texas, where they did point out that as a result of the merger, the merged entity, the hospital, would control 94% of the labor market for nurses. So there has been some movement recently. I see that I'm out of time, but I'd be happy to answer questions and to provide my ideas about what Congress can do about this.
Thank you, Professor Poser. And although you're not in the room, I want you to know you're here in spirit because I have your book. I do want to, before I introduce our next witness, I do want to ask unanimous consent to place into the record a Fortune magazine article to respond to Mr. Jordan's representations that is entitled, "Trump to Leave Office with the Worst Job Record Since Herbert Hoover." Without objection. I now recognize Dr. Kalachi for 5 minutes.
Thank you. My name is Brian Kalachi. I'm Chief Economist at the Open Markets Institute. I want to thank Chairman Cicilline, Ranking Member Buck, and the other members of the subcommittee for the opportunity to participate in this hearing. I will just say at the beginning, I feel a little bit at home here. I grew up in Cranston, Rhode Island, just outside of Chairman Cicilline's district. And just yesterday, I was in Crowley, Colorado, visiting my in-laws in Ranking Member Buck's district. And these issues are all across the country. So many of the issues we're discussing today have been around really as long as there have been markets for labor, as long as there have been labor markets. Back in 1776, Adam Smith argued that there was a baseline power imbalance between employers and workers. Furthermore, Smith was outraged that Parliament, the British Parliament, put its thumb on the scales in favor of employers. For example, by authorizing employers to get together and lower wages while prohibiting workers from getting together, what we now call unionizing, to attempt to raise wages. Now, since that time, our laws have evolved quite a bit to address some of the issues that troubled Smith. We left the United Kingdom and Great Britain, for example, but Congress passed antitrust laws specifically to prevent and restrain combinations of capital. And then it passed laws allowing and even encouraging workers to legally combine into unions. Congress also legislated specific labor protections to regulate wages and working conditions. However, over the past few decades, antitrust has unfortunately taken a step backwards towards the conditions that so outraged Adam Smith. In particular, antitrust has largely missed the boat as large corporations have consolidated buyer power over both local labor markets and entire supply chains, suppressing wages and worsening working conditions throughout the supply chain. Recent research shows the local labor market concentration is high, has been increasing over time, and is especially damaging to workers lacking a union's protection. Meanwhile, recent research has also found that buyer power in supply chains accounts for about 10% of wage stagnation since the 1970s. Even with these facts, no merger has ever been blocked for its effects on labor markets. Second, antitrust has also been relatively absent as employers have supercharged their baseline monopsony power over employees through restrictive contracts like non-compete clauses, mandatory arbitration, and no poaching agreements that artificially suppress wages. The effects of these coercive contracts, as the chairman pointed out, have been doubly large for women and non-white workers. Finally, in a series of court decisions since the late 1970s, antitrust courts have facilitated large corporations' use of restrictive contracts to dominate and control non-employee independent contractors and small businesses. For example, Amazon outsources local delivery to so-called independent delivery service partners. But Amazon sets the rates that these independent businesses can charge, the routes they have to drive, even their labor practices. And this kind of domination and control hurts workers too. Small businesses with no control over their own prices, costs, and profits have little room to improve the wages and working conditions they offer workers, while employees of these firms lack legal rights against the corporation that actually controls their working conditions. And even worse is the so-called gig economy, where similar restrictive contracts are used to misclassify workers as independent businesses, stripping workers of all employment rights. And these workers risk treble damage, antitrust prosecutions, and lawsuits if they try to unionize. So to return balance to the economy, action is urgently needed to disperse concentrated power and prevent the abuse of workers. In recent months, Congress and the executive branch have taken important steps in this direction. The July executive order on promoting competition in the American economy contains a number of positive components, including the directive to the USDA to consider issuing a new rules under the Packers and Stockyards Act to combat buyer power in food supply chains, and the directive to the FTC to consider issuing rules banning non-compete clauses. The FTC should further consider, however, using its Section 5 rulemaking powers to restrict the use of exclusionary contracts and other vertical restraints or restrictive contracts by dominant firms to control non-employee independent contractors. The package of bills that the House Judiciary Committee passed out of committee in June address the competition issues posed by dominant tech platforms are a vitally important step in the right direction to restraining corporate power. However, since problems of economic concentration and coercive contracts extend well beyond tech platforms, general antitrust legislation is needed as well. Such legislation should explicitly protect workers and suppliers from monopsony power, prevent judges from allowing wage suppression in the name of consumer welfare, expand the labor exemption from antitrust prosecution to independent contractors, and finally close those loopholes, allowing corporations to enjoy control over their business empires, but without employment responsibilities through the use of these restrictive contracts. I see that I'm about out of time, so thank you. I look forward to answering any questions.
Thank you, Dr. Kalachi, and no surprise that you're bragging about your Rhode Island roots. So thank you for being here today. I now recognize Mr. Gross for 5 minutes.
Thank you, Chairman Cicilline, Vice Chair Jayapal, and Ranking Member Buck. My name is Dan Gross from Edison, New Jersey. I'm 49 years old, husband and father of 4. I drive a tractor trailer in the feeder network for United Parcel Service. I'm also a proud union member and been active in Teamsters Local Union 177 since I started with UPS 22 years ago. I'm honored to speak with you today about why reforming our antitrust laws is important to me and my fellow American workers. My career at UPS started in June of 1999. Like most of us at UPS, I started as a part-timer. I transferred into a full-time combination job in 2000. These combo jobs were the direct result of our national negotiations and a 3-week strike with UPS in 1997, which created tens of thousands of full-time jobs by combining multiple part-time jobs. After 2 years in a combination job, my seniority enabled me to transfer to a package car driver position where I delivered packages to businesses and homes in one of those familiar brown trucks. In October of 2005, again using my seniority, I was able to transfer to my current job as a feeder driver. As a feeder driver, I drive tractor trailers, transporting trailers full of packages between UPS delivery hubs to and from other large UPS customers. I've seen firsthand what large corporations try to get away with due to corporate greed when workers don't have a collective voice to demand decent pay and working conditions. My union has provided that collective voice at UPS for nearly 100 years. Unfortunately, our standards and those of hundreds of thousands of United States Postal Service workers are also under attack by a new type of company, a company that uses its dominant presence in e-commerce to exert power over its contractors and workers. The threat to the industry I work for is Amazon. I know that this committee has passed bills that are trying to take on the special threats of Amazon and other tech companies. I'm not here to speak to those bills. I want to use Amazon as one example of why you should also pass antitrust laws that address how the largest, most powerful companies have too much power over their workers and how that affects and directs employees and all the other workers in the industry. As a feeder driver, it's common practice for us to be offered access to the customer's facilities while we're waiting for our loads. Amazon stopped this practice to limit our interaction with direct Amazon drivers and drivers working for Amazon subcontractors or independent contractors. It seems clear to us, feeder drivers, that Amazon did this to exert control over the information the employees and contractors can share with each other about route deliveries, but also pay and working conditions. In addition, Amazon uses drivers that are paid varying rates that are below industry standards, possibly by as much as half, even before benefits are factored in. I have even been told that sometimes Amazon restricts the ability of so-called independent contractors to carry backhaul loads, forcing them into non-paying empty loads on their return trip. Amazon's dominant position as an e-retailer enables Amazon to exert its power in business relationships in ways that encroach upon the Teamsters collective bargaining agreement with UPS and directly impact my working conditions. The constant threat of losing or diminishing delivery volume has forced UPS to comply with Amazon's demand to utilize subcontractors and independent operators who are not subject to the collectively bargained rules that are designed to keep drivers and the public safe. Collective bargaining is the antidote to corporate dominance. My local, Teamsters 177, has won grievance settlements to address the above subcontracting and similar contract violations against UPS, currently has multiple pending grievances. However, we have limited ability to impact Amazon's continuing demands that UPS modify its procedures in order to retain the Amazon business. Similarly, also based on my experience as a package car driver and shop steward at UPS, I've noticed the growth of Amazon's last mile delivery network. While the drivers are in Amazon branded vehicles and now wear Amazon colors, they are not Amazon employees, but employees of one of the nearly 1,000 delivery service partner contractors. These DSPs work solely for Amazon. Amazon set this system up to exert total control while shifting all their risk and responsibility onto smaller businesses and, of course, workers. A direct impact of Amazon's demands can be seen in the creation of classifications of workers to satisfy Amazon's insistence that its contractors provide service on the weekends. In 2012, the contract that the USPS negotiated with Postal Service unions created a non-career letter carrier position to do Amazon package delivery on the weekends. In our UPS national agreement in 2018, a new delivery job classification was also created to accommodate the demands of Amazon for weekend delivery. If Amazon has the ability to dictate terms to entities like the United States Postal Service and UPS, imagine the control it has over small businesses like DSPs. I feel fortunate to be working in a field where workers have fought for and won industry-leading pay and benefit standards through collective bargaining. I encourage you to consider antitrust policy reforms that help to rebalance the power that corporations like Amazon have over labor markets. If we don't do something now, workers will be forced into dead-end, unsafe, and high-turnover jobs instead of enriching careers that allow our families to thrive. Thank you, and I look forward to your questions.
Thank you very much, Mr. Gross, for being here and for your testimony. I now recognize Ms. Payton for 5 minutes.
Good morning. My name is Nyla Payton. I'm an administrative assistant in the pathology department at UPMC Presbyterian Hospital. I want to start by thanking the committee for inviting me to testify today. I live in Pittsburgh with my 2 children. My older son, Tyjon, goes to a Pittsburgh public school. My youngest, Roman, goes to a Pittsburgh public preschool. I do my best to keep up with school announcements and participate in school board meetings because I want them to have a great quality education. I have worked at my job for almost 16 years. I trained for it at the Bidwell Training Center, where a lot of administrative assistants and UPMC workers can get their training. The pathology department is important to everything we do at UPMC. I make sure test requests and results get to the right place, so I have to understand medical terminology. I also make sure that our department remains HIPAA compliant. I'm really good at my job. I have good relationships with everyone, and I bring a positive attitude to work. I like knowing that my work helps sick people, but my job does not pay what it should, and I am not treated with the dignity and respect I deserve. After 15 years on the job and 2 promotions, I make $19 an hour. That might sound like a lot, but a living wage for my family type in Pittsburgh is $28 an hour. People just starting in my position or any service position make $15. Every service worker I know struggles to make ends meet. Our medical insurance is very high, and we have to use UPMC facilities. I have medical debt to my employer, and so do many of my coworkers. That means we skip or postpone treatment because copays and bills are just too high. Management knows we are struggling. They sometimes send us tips for stretching our budget. One time, they told us to save on transportation costs by riding our bikes to work, something I don't plan to do in the snow, especially with a small child. They direct us to apply for government assistance, which some of us workers make just too much to qualify for. We also have an internal UPMC food bank. Where is the dignity in that? As for respect, here's an example. In the last big wave of the pandemic, I told my manager that workers wanted better PPE and information so we could stay safe in the hospital. When I expressed that I thought we should get hazard pay, my employer told me that because we work in healthcare, that we signed up for this and I should stop complaining. But I'm sorry, nowhere in my orientation did it mention putting my life on the line. And I understand that we have to make a hospital run in a pandemic, but you signed up for this is not the right answer. The right answer is your life is valuable. Let's do everything in our power to make sure you are informed and safe. UPMC did not even apply for the hazard pay that the state was offering. Sometimes people ask, why don't you just get another job if you don't like the one you have? I love what I do, and this is where you need to understand just how big UPMC is. 2 decades ago, there was no UPMC. Pittsburgh had many independent hospitals, but over the past 20 years, UPMC has grown from one hospital, Western Psych, to become a $23 billion company. It now owns Mercy, Presbyterian, Montefiore, Shadyside, Children's, McGee, McKeesport, East, and St. Margaret's, and that's just in the Pittsburgh area. We all have the same corporate policies, so what's the point of going from Presby to McGee? There's almost nowhere else to work if you're a healthcare worker. But UPMC is so big that they actually affect the whole labor market, even outside of healthcare. Last week, I looked at administrative assistant jobs not at UPMC. There were 800 of them in our region. I eliminated the part-time jobs. Then all the jobs that paid the same or less than mine. There were 40 left. Then I eliminated the night shift jobs because I have children. And the jobs so far away, you need to have a car. There were just 2 jobs left. UPMC employs 92,000 workers. Nobody else has enough jobs to force them to compete for our time and our skills. Instead, UPMC sets the ceiling for everybody. That's why leaving UPMC is not a realistic path to a better life. Leaving just means that we have to start all over again. I do not want to waste time looking for something that does not exist. I want to work to improve the job that I have. I want to improve all the jobs that thousands of my UPMC coworkers have. 2 generations ago, Pittsburgh had an employer as big and impactful as UPMC. It was called US Steel. Workers at US Steel had their union. So instead of a worker starting at $15, a worker started their first day at over $21 an hour in today's money and went up from there. A steel worker with my years of service would be vested in a pension and making $33 an hour. Steel jobs lifted up every other job around because if employers wanted workers, they had to compete with US Steel. If we create good jobs for workers at UPMC, we can do the same thing and create good jobs for everyone. And that's what I want to do. Thank you for listening and have a great day.
Thank you, Ms. Payton. I now recognize Commissioner Wilson for 5 minutes.
Chairman Nadler, Ranking Member Jordan, Chairman Cicilline, Ranking Member Buck, and members of the committee, thank you for the opportunity to testify. I will first provide context for the labor issues we're discussing today. Then I'll address antitrust issues pertaining to labor markets. And finally, I'll touch on procedural irregularities at the FTC that regrettably have precluded a robust dialogue on these and other policy issues. Our antitrust laws are more than 100 years old. Periodically, we ask, are they capable of addressing new industries and dynamic markets? Previous periods of reflection have led us to answer yes. Many ask the same question now, but the current version of the question is notably different. First, concerns about the dynamic tech industry are not limited to antitrust. Some focus on the collection and use of consumer data. Federal privacy legislation, I believe, is the solution. Others are concerned about content curation and censorship. Reforms to Section 230 may be appropriate. These concerns merit discussion, but just because we hold the hammer of antitrust law in our hands does not mean we should treat every concern as a nail or we risk bludgeoning our entire economy. Each concern deserves the appropriate tool. For antitrust law, the many enforcement actions and investigations against big tech confirm that process has begun. We should let those cases play out before overhauling our antitrust laws. The second difference is that current concerns about antitrust extend beyond the dynamic tech industry. Today's hearing on labor and monopsony highlights one of those broader goals. But the antitrust laws as they exist today embody concepts like monopsony and prohibit no-poach agreements and unreasonable non-competes. Antitrust enforcement as it exists today reaches anti-competitive conduct that harms labor and middlemen, not just the end consumer. Today's antitrust reformers propose changes that would transform not just our antitrust laws, but our economy. Substituting our sound economics-based approach for one that picks winners and losers will incentivize rent-seeking and regulatory gamesmanship instead of competition and innovation. Everyone, including American labor, will suffer. Turning to monopsony and labor issues, let's start with occupational licensing. Licensing regimes may advance legitimate health and safety goals, but frequently those who are already licensed use those regimes to insulate themselves from competition. The FTC has sued when incumbents suppress competition through state boards. The FTC has also submitted hundreds of comments and amicus briefs urging policymakers to consider the impact of licensing restrictions on competition, especially in the healthcare sector. Federal and state restrictions were relaxed during the pandemic to boost the availability of scarce healthcare personnel. I hope policymakers assess the impact of those changes and permanently eliminate unnecessary restrictions. And I thank America's healthcare workers like Ms. Payton for their service to us during the pandemic. Regarding monopsony, the FTC and DOJ have prevailed in monopsony cases, and so have private litigants. Both mergers and business practices may create unlawful monopsony power, even when ultimate downstream markets are not impacted. And I would welcome the opportunity to discuss the FTC's scrutiny of mergers for monopsony issues in recent years, including a challenge to a merger involving the sale of blood plasma by donors. With respect to non-compete provisions, state jurisprudence and common law provide rich guidance on non-competes. Some states have laws explicitly prohibiting employee non-competes, and other states like Pennsylvania are considering laws on this topic. And state AGs have had notable successes in this area. For now, given the economic evidence is mixed regarding the impact of non-competes on employees and the ancillary impact of non-competes, like investments in employee training and R&D are relevant as well, I believe we should listen to Justice Brandeis and let the states continue acting as laboratories of democracy. The final labor issue pertains to no-poach agreements. FTC DOJ guidance warns that wage fixing and no-poach agreements may be prosecuted criminally. Both federal and state enforcers have been active in this area, and the FTC brought a case involving home health staff in 2018. Turning to my third topic, the issues we'll discuss today and other potential antitrust reforms merit thoughtful discussion. Traditionally, the FTC has played a leading role in the antitrust policy debate, largely because of its strong bipartisan dialogue, which has benefited from the vibrant input of stakeholders. Regrettably, new FTC leadership has made meaningful dialogue among commissioners and between the commission and its stakeholders difficult. In closing, I thank the committee for this opportunity to testify, and I look forward to answering your questions.
Thank you, Commissioner. I now recognize Professor Kobayashi for 5 minutes.
Thanks. I thank the committee for inviting me to testify today. I want to say at the outset that ensuring that the antitrust laws protect both workers and consumers from the effect of monopsony should be an important goal of antitrust. And the effects of classical monopoly results in harm to both workers, consumers, by simultaneously reducing output, decreasing workers' wages, and increasing prices to consumer. My testimony today will focus on proposals to use the federal antitrust laws to control the use of non-compete agreements, irrespective of the context in which they are used. Any such action should be based on robust and systematic evidence of the negative effect and ubiquitous effect of NCAs on both workers and consumers. Well, there certainly is some evidence that the application of non-compete agreements in some settings harm workers, and Evan Starr has done great work in this area. There is also evidence that non-compete agreements, especially when accompanied by notice and consideration, result in benefits that both workers and firms achieve. In addition, non-compete agreements can simultaneously reduce worker mobility and wages, but also harm consumers. There's a recent article by Gurin, Stoffman, and Yonker published this year in the Journal of Financial Economics, which studies membership in the broker protocol. Protocol member firms agreed not to enforce post-employment restrictions by promising not to sue departing brokers for taking their client information with them to other member firms. One effect was that the brokers were happy They had increased mobility and they achieved higher wages. But consumers were harmed. The authors present evidence that consumers paid higher prices to protocol firms and suffered higher levels of broker misconduct. Second, to the extent that problematic uses of non-compete agreements and other restrictive employment agreements have been identified, the preferred solution would be to address these identified problems specifically, rather than enact a widespread ban through the use of, through the federal antitrust laws. Legislative solutions to specific issues should be identified by robust and credible research. And the well-developed body of law, as Commissioner Wilson just said, actually follows an approach which recognizes the mixed and potentially beneficial use of NCAs. I think that the committee should pause and make sure that it is not going to interfere with the robust and widespread approach of the states, where the vast majority of states allow the reasonable use of NCAs but ban the unreasonable use. The Uniform Law Commission just passed at the end of July a uniform law which would take many of the protections in the majority of states and apply them in a uniform law if enacted. Just as it would be wrong for antitrust policy solely to focus on output markets and monopoly and ignore the effect of monopsony, it is also wrong to base antitrust policy only on the effect on workers without considering the downstream effects. I think that one example that Eric mentioned was hospital mergers. There's actually a great article by Prager and Schmidt that I think just published in the American Economic Review that shows that hospital mergers that occurred from 2000 to 2010 caused wage stagnation for skilled hospital workers. You have to sort of understand the context of the data they have. The period right before their data set, the 1990s, was a period in which the federal agencies challenged but lost 7 straight hospital mergers. In response to that, then Chairman Uris in 2002 convened a task force. The task force looked at the causes of these losses, including problems with market definition, and also got the Bureau of Economics to produce retrospective studies to show that these mergers caused double-digit price increases. As a result of this, things were turned around, and it's not surprising that these mergers, which were allowed to harm consumers, also harmed workers. I look forward to your questions.
Thank you, Professor. We will now proceed under the 5-minute rule with questions. I'll begin by recognizing the chairman of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Ms. Payton, I was particularly struck by your testimony. You told your manager that workers in your hospital needed more information and better personal protective equipment to stay safe during the pandemic. Your manager said that you signed up for this because you work in healthcare and you should stop complaining. Do you think your employer could be so dismissive about providing PPE if there was more competition for healthcare employees in Pittsburgh? And did you and your colleagues sign up for an unsafe work environment?
No, we did not sign up for an unsafe work environment. We signed up to provide quality patient care. And if we had a union at UPMC, we would be able to voice our opinion about getting better PPE, and we would have that option.
Thank you, Mr. Gross. In your testimony, you mentioned that changes in the logistics and delivery industry are putting pressure on employers to reduce pay and benefits and make other changes that reduce standards and make these jobs safe. What are the changes in your industry that are having a negative effect on wages, benefits, and working conditions? And are these changes endangering worker safety? Are they endangering the public?
Thank you, Congressman Nadler. Right now in our industry is large corporations like Amazon being allowed to use third-party workers and subcontractors instead of actually utilizing their own employees. So it's putting downward pressure on wages, industry standards, and benefits.
And are these changes endangering worker safety and endangering the public?
I believe that it does endanger worker safety because of they hold them to such high levels of productivity that it forces the workers to rush and cut corners, and they don't follow the same safety and training that we receive at UPS or at other unionized corporations. And I'm also aware of some of the dangers to the public would be the DSP third-party providers that they utilize. Amazon leans on them, pushes them, and wants them to perform, and they cut corners as far as like vehicle safety, maintenance, things of that nature, because they're under constant pressure to get out there on the road and deliver. They're scared of losing their business, and I do believe that in that effect it does cause a safety hazard to the public.
Thank you, Mr. Posner. You wrote an op-ed last week in the New York Times in which you explained that monopolists use their market power in labor markets to hire fewer workers, leading to unemployment and lower economic growth. Because there are fewer workers, these firms supply fewer goods, resulting in higher prices for constituents. Other than higher prices, are there non-price effects that harm consumers? And how are the antitrust and courts enforcers and the courts responding to evidence that highly concentrated labor markets harm workers and consumers?
Yes, well, one would expect that if employers want to save labor costs, they can do so by reducing, if they want to save money in the product market, they can do so by producing lower quality goods as well as more expensive goods. There is economic evidence of that, but I wouldn't be able to cite it off the top of my head. Now, in antitrust law, there tends to be a rule that you only look at the market directly affected by the defendant's behavior. So if workers bring an antitrust case, you look at the impact on workers. If consumers bring an antitrust case, you look at the impact on consumers. So normally, if workers brought an antitrust case, you would not look at the impact on consumers, but in a way, it doesn't matter, because generally speaking, if monopolists reduce employment, as they appear to do, then you would expect lower output and higher prices, and as you say, lower quality goods.
Thank you, Mr. Kalachi. Mergers that enhance market power can have non-price effects on worker safety. For example, Ms. Payton and Mr. Gross testified about worker and workplace safety issues. Do antitrust enforcers typically consider non-price effects in labor markets as part of an agency's merger review? And if not, why not?
When I was bureau director, we did have a good focus on.
Excuse me, sir, I believe this question was for Mr. Karachi.
Oh, Karachi, sorry.
Kalachi, yes.
Yes, my fault, but also the time of the gentleman has expired, but I'll give the chairman the witness a few seconds to answer the question.
Yes, just very briefly, there is a new paper, relatively new, from Aaron Sojourner, Iona Marinescu, and I forget their co-authors, showing that monopsony has effects on non-wage aspects of work, including violations of safety laws. And there was also a report in the Washington Post that the Amazon subcontracted delivery service partners have higher injury rates than even Amazon itself. So that would seem to back up what Mr. Gross was saying. As to, to my knowledge, effects on worker health and safety of mergers has not been considered. I'd have to do a deeper check, but I don't think that's been considered, and it should be.
Thank you.
I yield back.
Thank you. The chairman yields back. I now recognize the gentleman from Colorado, Mr. Buck.
And with the chairman's permission, I defer to Mr. Gates from Florida.
Mr. Gates is recognized.
Thank you, Mr. Chairman. This is my favorite subcommittee in my half-decade in Congress, and in no small part because of the way you've led it. I am incredibly proud of the work we have done to address some of these anti-competitive practices of these monopolistic entities. And I was particularly persuaded by the testimony of Mr. Gross regarding how that market power of big businesses like Amazon can limit the ability of workers to have any type of meaningful negotiation. Congresswoman Jayapal led legislation that the chairman of the committee, the chairman of the subcommittee, Mr. Buck, and myself supported that would force the breakup of companies like Amazon into smaller entities. And I wanted Mr. Gross's perspective on that. Do you believe, as a negotiator, that would improve the position of workers to break up companies like Amazon and other big tech companies into smaller entities?
Well, I'm not an expert on this field. You know, obviously, I'm just a driver at UPS and the shop steward for my union. But what I would say, though, is that it might not necessarily be necessary to break up the size of the company, but just to allow or force the company or encourage the company to employ the workers that it's utilizing. So instead of using third-party individuals and leaning on them and chewing them up and spitting them out, have real employees, you know, give them real wages, allow them to have a collective bargaining unit agreement. And I think that way you would get more productivity out of them in the long run and still be able to run a successful business.
I appreciate that perspective. My concern is that if they're able to stay so big, even if we used the awesome powers of the federal government to force these relationships out of independent contractor relationships into employment relationships, they're still so big that they could reduce the contributions of those employees with the strength that they have. And it is one of the reasons why we had bipartisan support on this committee for those bills. But Mr. Chairman, I'm deeply disappointed that those bills haven't been called up for a vote. It seems a bit odd to be here talking about positive impacts of legislation the subcommittee has passed when the full House has had the opportunity in prior weeks to take up these bills and they haven't. And I have to wonder why that has happened. And so, Mr. Chairman, I seek unanimous consent to enter into the record a piece from the New York Times entitled "Tech Giants Fearful of Proposals to Curb Them, Blitz Washington with Lobbying."
Without objection.
And so that could be a reason, the power of lobbyists in this town to make things tougher for workers. I guess there could be other reasons too. Mr. Chairman, I would seek to enter into the record a piece from Yahoo News entitled "Tim Cook Reportedly Called Pelosi to Deliver a Warning About Congress's Antitrust Bills."
Without objection.
So maybe it's the lobbyists, maybe it's the power of these very powerful CEOs making personal calls, but it could even be something more sinister. Mr. Chairman, I seek unanimous consent to enter into the record a Fortune.com piece entitled "Speaker Nancy Pelosi's Husband Cashed in on Big Tech Just as Congress was set to pounce."
Without objection.
And in that article, there's discussion of the spouse of the Speaker of the House making a $6 million call on stocks that netted $5.3 million while we're not moving these bills. So I thought that was a little odd. I thought that was weird. We moved bipartisan legislation out of this subcommittee, and just as we're considering it, and it might be bad for big tech, the Speaker's spouse goes and buys all this big tech stock, and then lo and behold, here we are with the bills not called up. And it just makes you wonder, did somebody know something? Was somebody acting on information? And it could have been the power of the lobbyists and all the money that they donate to members of Congress on both sides. It could have been people like Tim Cook calling, but here's what we know. These bills aren't coming to the floor. If they were coming to the floor, they would have been on the floor in prior weeks. And so now we sit here with this great work likely extinguished in its tracks for one of these unfortunate reasons. And Mr. Chairman, I know we've got Chairman Nadler's MORE Act coming up soon. And one thing we learned in the marijuana movement is sometimes you got to lose votes on the floor. Sometimes you got to put up the votes, you got to lose, and then year after year, you make a little progress, you get further down the road. And even if these tech bills can't pass, I would encourage you to talk to the Speaker and put them up for a vote. And I know she said she won't put up votes that don't pass, but if it could at least give us a measuring tool to be able to come back and work to persuade our other members. I thank the chairman for his indulgence for going over
Yeah.
time, and I yield back.
And I want to reassure the gentleman that I am working very closely with the ranking member of the subcommittee to be sure that our colleagues who have not had the benefit of the 16-month study that we conducted, where we, I think, learned a lot about this marketplace, understood what these complicated bills do. We want to be sure that our colleagues are fully briefed up, and we are committed to making certain these bills come to the floor, not just for a vote, but for a vote that prevails because of the hard work that's been done, and we are grateful for your ongoing and strong support. But this is an important priority for me, I know for all the Democrats in our caucus, and certainly for the chair of the full Judiciary Committee, and working very closely with Mr. Buck to be sure we get to that point. And thank you again for your support of our investigation and the legislation. And with that, I now go to the gentleman from New York, Mr. Jones, for 5 minutes.
Thank you, Mr. Chairman, and to the chairman of the full committee, Nadler, for holding this important hearing. Thanks as well to our witnesses, and especially to Ms. Payton and Mr. Gross for your courageous testimony. It's about time that we confronted the power the biggest corporations wield over workers, monopsony power. Just as monopoly power enables corporations to dictate the prices and quality of the things that we buy and the services that we rely on, so monopsony power enables corporations to set our wages and our working conditions, dominating the job market. Today's testimony makes one thing clear. Restoring competition in the labor market is essential to restoring economic and democratic power to the American people, to making sure that everyone gets their fair share of pay and say. And as to Commissioner Wilson's concerns about the FTC's process, let me just say this. The subcommittee only received the commissioner's testimony around 8 p.m. last night, even though this hearing was postponed by a week. So it's somewhat surprising to hear complaints about the process at the FTC at a hearing on protecting the economic liberty of American workers. We have frontline workers who have taken time off to testify about their experiences today, and that is what we should be focusing on in this hearing. Professor Posner, as you have testified, mergers are a central cause of corporations' tremendous power over workers. Ms. Payton has experienced that firsthand. Yet the DOJ and the FTC have never challenged a merger to protect workers, not even once. How should we strengthen merger review to empower workers and prevent corporate power from consolidating even further?
The example of UPMC, which Ms. Payton provided, is truly an amazing story. As she mentioned, the current hospital is the result of dozens and dozens of mergers. And the single company controls 40 hospitals, more than 40 hospitals in the Pittsburgh area, and thousands of clinics. It's a true monopolist and a monopsonist. How all those mergers could have gone through when we nominally have a merger review process is a mystery to me. So to answer your question, I think the answer is actually straightforward. The Justice Department and the FTC currently have what are called merger guidelines, where they provide certain rules or guidelines that regulate when mergers are permitted and when they're forbidden. The guidelines are probably too weak at the moment, even with respect to product markets, but they say nothing about labor markets. And so if Congress were to direct the FTC and the DOJ to add a section on labor market, or Congress could just legislate this directly. And what it could do is it could provide certain thresholds when certain mergers occur that have major labor market effects, and this can actually be quantified to be very precise. The merger will be presumptively blocked and would be only permitted if the merging companies can prove to the satisfaction of a court that as a result of the merger, efficiencies would be produced that would result in higher wages and better working conditions than if the merger did not take place. There's a lot of experience on the product market side with this type of analysis. I think it would be fairly simple for regulators to use this type of analysis for the labor market effects of mergers.
Thank you so much. Dr. Kalachi, in your written testimony, you've said that we should set out clear, bright line rules that make it easier to block harmful mergers. Would you please elaborate?
Sure. So actually, this is a great follow-up to Dr. Posner's point. A lot of those, those sort of fact-intensive, demonstrations of efficiency allow, both parties hire economic consultants, they hire law firms, and judges are not specialists in economics. So those sort of processes allow, consultants can muddy the waters, make it very difficult for judges to reach a clear decision. So, I would say it'd be better to have, sort of very clear rules, clear guidelines that apply to these situations rather than, relying on, allowing defense to sort of make the case for these efficiencies that tend not to really arise. So the product market, to me, actually shows how the labor market should not follow the product market case.
Thank you, Doctor. Mr. Chairman, I yield back.
The gentleman yields back. I now recognize the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. And I'd now ask unanimous consent that 2 articles be placed in the record. One that's entitled California Occupational Licensing Laws Shouldn't Kick People When They're Down. The second one is from the Mercatus Institute. It says California Occupational Licensing Barriers to Opportunity in the Golden State.
Without objection.
Thank you, Mr. Chairman. Mr. Chairman, I want to thank you for your opening remarks that also touched on the need to rein in the inevitable growth by government of regulating and wanting a license for everything. My home state has managed to reduce the number of entrepreneurs, reduce the number of people who get to work for themselves, and increase the number of people waiting to work for anybody based on licensing. At a time of COVID, they managed to have a situation in which you could go to school, you could get the education, but you couldn't get your license because people who were being paid full pay by the state were not granting testing for more than a year. This does create an opportunity for a bipartisan effort to define when and how particularly private entities can require licensing. I look forward to working with you on that. I'd like to now shift to Commissioner Wilson. Commissioner, you, in your opening remarks, did talk about, and in your written statement, about the North Carolina State Board dental examiners, where dentists conspired to exclude or to include teeth whitening under their purview to the detriment of people being able to do something that you and I could go to the drugstore and buy the same materials, but would not be able to have it done for us. Could you expand on that case and why it begs for the kind of reform that I think we're talking about here today?
Thank you for the question. So that case is one notable case in which incumbents, the dentists on the dental board, I believe 6 of the 8 people on the dental board were dentists, erected barriers to entry to keep competitors out of the market. We also, at the Federal Trade Commission, brought a similar case against South Carolina dentists who actually interfered with the delivery of preventative dental services to economically disadvantaged children in public schools. The hygienists had been going to public schools and providing teeth cleaning for economically disadvantaged children. And the dentists decided that they were going to enter a regulation that said that hygienists could not practice without having basically a dentist looking over their shoulder, and the Federal Trade Commission challenged that as well. And so you're absolutely right to focus on these issues. Absolutely, states have an interest in protecting the health and safety of their constituents, but sometimes incumbents actually use those regimes to insulate themselves from competition as opposed to protecting consumers. And that's where the FTC gets involved.
Well, I appreciate that. And Commissioner Wilson, you may not be prepared to opine on this, but in California, where AB 5 became law, it dramatically reduced competition because it eliminated the ability for massive classes of individuals to form their own sole proprietorships or small companies. Isn't that another example, at least in principle, where competition is reduced anytime government limits the ability of people to essentially start companies.
So you're right, sir, that I am not familiar with that legislation, but traditionally the Federal Trade Commission has been very interested in economic liberty type issues, ensuring that people who are interested in practicing a trade or moving across state lines or practicing to the full extent of services for which they're licensed have the opportunity to do that so that they can have the dignity of earning a living wage. And anything that inhibits that, unless it is directly tied to protecting health and safety, would be and should be suspect.
Well, and finally, many of the comments made here today are about moving that the Federal Trade Commission and other federal organizations move the bias from the government proving that competition is somehow hurt to the individual company proving that it is enhanced, whether in labor or in other competition. Do you think that is a dangerous trend or direction?
I do. That does not comport with our innocent until proven guilty approach to law in this country.
Thank you. I yield back.
I thank the gentleman. I look forward to working with you on the licensure issue, and also hope that the example of California that bans non-competes in its entirety might also inform our work together. And now I'll yield to the gentleman from Maryland who's been a leader on the impact of excessive licensure on American workers, Mr. Raskin, for 5 minutes.
Mr. Chairman, thank you so much. Thanks for calling this important hearing. I'm concerned about the rampant misclassification of employed workers as independent contractors in order to evade and undermine worker protections, especially in the so-called gig economy, even though Section 6 of the Clayton Act shields the, quote, labor of a human being from general antitrust scrutiny. Courts have narrowly construed the exemption so that it doesn't include independent workers, ranging from independent doctors and lawyers to for-hire drivers. Mr. Kalachi, can you explain how the rampant misclassification of employees as independent contractors exposes working people to attack under the antitrust laws?
Sure. So, yeah, basically, yes, Section 6 of the Clayton Act and the Norris-LaGuardia Act and the National Labor Relations Act all attempted to exempt workers from antitrust prosecutions for coming together to collectively bargain. So of course there is an incentive for companies to misclassify their employees as independent contractors, so those workers don't have access to those rights, and they can in fact be prosecuted for collusion. If we were able to get on the labor law side, get those workers classified properly as the employees that they are. And then on the antitrust side, sort of stop going after these small players, church organists, independent contractors that remove the incentive to misclassify.
Over the last few years, antitrust enforcers under both Democratic and Republican leadership have committed to policing anti-competitive conduct in labor markets. How can the antitrust agencies bolster enforcement in labor markets under current law?
So we can revise the merger guidelines to more explicitly take into account effects on workers.
Earlier this year, Judge Diane Woods testified that Congress intended the antitrust laws to apply to the harmful effects of concentrated economic power and not just short-term reductions in consumer welfare or economic output. How has the shift in recent decades away from this legislative purpose of the antitrust laws towards the goal of just narrowly promoting consumer welfare harmed workers and small businesses and the political economy generally?
Yeah, so that it makes it more difficult to get at anti-competitive conduct, unfair methods of competition, unfair conduct that harms workers. So you can get at harms to workers indirectly if the monopsony power results in a decline in output. But that is not always the case, right? There are times when, particularly there's an excellent recent paper by Hemphill and Rose showing that there are cases where monopsony power may not result in a decrease in output, but rather a redistribution from employers to employees. So we need to be able to take those into account, and the current application of the antitrust laws does not allow us to do that because we're so wedded to this idea of either, we call it either consumer welfare or output maximization. It does not allow us to address these harms to workers.
Well, and how are you recommending that Congress amend the antitrust laws in order to reassert the primacy of protecting against abuses of concentrated economic power, including in the labor markets themselves?
Gotcha. Sorry for not getting so directly to your point the first time. So one way to do that is to not allow offsets, right? So if workers' wages decline, if their injury rates climb as a likely result of a merger or because of employer collusion, that could be I lost my train of thought. Hold on. Not allowing that to be offset against gains to consumers or to another counterparty in the market.
You've noted that the narrow lens for antitrust policy over the last few decades has loosened restraints on franchising to the detriment of workers. How could changes to the antitrust laws address the harmful consequences of this franchising model on small businesses and on employees?
Sure. So that gets to Representative Ice's point about sort of entrepreneurship. So what antitrust has allowed since basically the 1970s is allowed large corporations to control and really dominate non-employee independent contractors and small businesses through contracts. So rather than having a chain of McDonald's, each restaurant is owned by a so-called independent contractor who has no control over their business practices. That means that they can't raise the prices. That means they can't choose their own suppliers. So they have no room to raise wages. And in fact, the McDonald's franchisee told, I think it was the Washington Post, that McDonald's told her just pay your workers less when she complained about these kinds of vertical restraints.
Gotcha. Thank you very much for your testimony. I yield back to you, Mr. Chairman.
The gentleman yields back. I now recognize the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. Appreciate that. Grateful to the witnesses for sharing their insights today. My colleagues on the left often talk about how consolidation and corporate concentration are bad for American workers, but they sometimes seem to miss the point that increasing regulations on businesses actually leads to consolidation of industry power in these big mega companies. Professor Kobayashi, what do you think of the proposition that unnecessary regulatory hurdles creates barriers to entry and reduces competition?
Thank you for the question, Congressman. Certainly it is a reality that often large firms are better able to deal with onerous regulations or regulations that are just costly. A good example, I think, is Catherine Tucker's work on privacy regulation. Who best is able to deal with that type of cost and complexity? It's Google. And it makes Google stronger, and it also makes it harder for small firms to compete. It's not saying that Google has done anything wrong, but I use it all the time because I think it's the best search engine. But it does, in many cases, cause asymmetric abilities to deal with costs and promotes larger firms over smaller ones.
Often government has good intentions, but when you have to actually apply it in practicality, it is counterproductive. Instead of focusing our discussion today on implementing more regulations, shouldn't we be focusing on real reforms? And if so, what would be the primary focus? I mean, where should we put our attention first?
Well, one thing that I think that is important in my years being the bureau director at the FTC, the problems, we would get problems, we would see research, we would get questions from Congress, and the chairman would ask us to deal with these issues. Even before I got to the FTC, Joe Simons, who's the chairman when I was there, we had many conversations in the period before we both got to the FTC about labor monopsony. He was, he was very concerned about it. And one of the things we did to address labor monopsony in mergers was we put specs in the Hart-Scott-Rodino questions to sort of deal with labor monopsony issues, not just looking at product markets, but actually making the firms give us data about commuting zones and labor wages and the like. We also continue to do retrospectives. When I was there, there's a state, a bunch of states have these certificate of public advantage programs in which we want to block mergers, but they say that, no, we're going to allow the merger that you think's anti-competitive under our COPA laws. And what we do is we study them. One of my economists at the time actually then went to CMS and asked for data on labor wages just so we can actually have some idea of what the effects were and have an evidence-based basis for any policy changes that we're going to make.
Those are good ideas. I've got just a little over a minute left. Let me just ask you quickly, how will top-down arbitrary regulations such as President Biden's vaccine mandate on businesses with 100 or more employees affect the marketplace?
Well, a bit out of my expertise, but my guess is that the use of top-down mandates are often well-intentioned, but you'd want to know what the unintended consequences might be. There are some people who would not want to take those into account, and there are some who will have a hard time dealing with it. But I think the marketplace is, my university has vaccine mandates, and we have to wear masks. So,
well, what we're seeing in practice across the country is large-scale resignations, and we have any number of industries that are really struggling right now. At the worst possible time, the mandate hits, and so it's a real problem. I'm out of time. I'll yield back.
The gentleman yields back. I now recognize the gentlelady from Florida, Ms. Demings, for 5 minutes.
Well, thank you so much, Mr. Chairman, and thank you to all of our witnesses for joining us today for this very, very important hearing. Dr. Posner, you said that there is no consideration at all of merger's effect on labor. And let me just say that's a powerful statement, that's a powerful realization, and one that I certainly believe is sad but true. Do you believe that non-compete agreements are freely entered into by workers? And do many workers have the bargaining power to negotiate these agreements?
Thank you for the question. Research suggests that certainly for lower income, less educated workers who are required by their employers to enter non-competes, those workers do not understand what the non-competes mean. Often they don't even learn about the non-competes until they show up at work. They're not in a realistic position to say, okay, but you have to pay me more. I mean, that's just not how the world works, and that's been confirmed by academic research. For quite sophisticated people, like executives who can hire lawyers to advise them, they appear to be informed about these non-competes and may very well be compensated for the restrictions that they impose on them. But I do want to add that even when people voluntarily consent to non-competes and receive wage premium as a result, that can have serious anti-competitive effects. And I'll give a quick example. Imagine a hospital in a small town. It ties up all of the physicians and nurses with non-competes and compensates them. Now, a new hospital or clinic wants to enter the town and needs workers. Well, it can't compete for these workers because they're tied up for a year or two, and they would have to quit and not work in their profession for a couple of years before they could work for the new employer. So these non-competes, even when voluntarily consented to, can have serious negative effects on competition.
Thank you so much, Professor. Mr. Gross, you said something at the beginning of your testimony too, and it was maybe viewed as small, but I thought it was also powerful. As you talked about the workers, you said fellow American workers. And it was just something that was good to hear in this political climate where we tend to like to pick and choose winners and losers. I think our responsibility on this committee is to leave no American worker behind. And so I just thank you for being here and testifying today. You mentioned the stark difference in prevailing wages between unionized UPS drivers and Amazon drivers. Why do you think there is such a big difference in the wages? I know you talked a little bit about that, but if you could just drive that point home for us, please.
Thank you, Congresswoman. I think one of the biggest differences is that unionized workers, we are employees of the corporation, and where Amazon's using these DSP delivery drivers, they're not actually Amazon's employees. So in that essence, it allows Amazon to save money and also not share in its profits with the people that are actually making the money for Amazon. So that's definitely one of the ways.
How would you respond to people who would say that consumers really like Amazon and they want two-day delivery, and that Amazon's practices are reducing prices for consumers and workers who dislike it should just find a different line of work? How would you respond to that?
Well, I don't think there's anything wrong with consumers liking Amazon and liking two-day service. We provide second-day airs at UPS. We were the ones that were providing the service behind the scenes for Amazon for a long time. But, you know, what was the question again?
What would you say to people who seem to want to kind of ignore, you know, the differences in wages, working conditions, and all of those things because they like the service that Amazon gives? I think it goes back to the way you do business matters too.
Yes, the way you do business matters. And I would say there's nothing wrong with liking Amazon, but you would like them a lot more if they had employees that were unionized and that were able to provide the excellent service that unionized workers are able to provide.
Thank you so much, Mr. Gross. Thank you to all of our witnesses. Mr. Chairman, I yield back.
The gentlelady yields back. I now recognize the gentlelady from Minnesota, Ms. Fishbach, for 5 minutes.
Thank you, Mr. Chair. I've got just a couple of questions for Commissioner Wilson. You know, Commissioner Wilson, in this subcommittee, there's been quite a bit of talk about the proper focus for and the limits of antitrust law. And one premise of this hearing seems to be that antitrust is responsible for and can solve many of the issues that American workers are facing. I just wonder if you could take just a couple of minutes to talk a little bit about what antitrust focus has been in the past and what it is today.
Thank you for the question. So I would start by saying that the analytical framework that we use is called the Consumer Welfare Standard. And so in our analysis, at the forefront of our mind certainly is how consumers will be impacted by conduct or by mergers. That is not limited to an analysis of short-term price effects. In fact, we also think about innovation, we think about quality, we think about choice, we think about whether barriers to entry will be erected that will inhibit new entrants from coming in and further lowering prices. And so even though it's called the Consumer Welfare Standard, it is and is characterized as being focused on short-term price effects. That is actually incorrect. First of all, as I've described, we do think about innovation and quality and choice. Second of all, in the Weyerhaeuser case, I think it's a great example of how we actually do look at impacts of monopsony power, even if there is no impact on output. And so I just wanted to respond to Dr. Kalachi's statement that in fact, he said we can only challenge monopsony power under existing antitrust laws if there is a decline in output. But in fact, in the Weyerhaeuser case, that was not true. Also in the horizontal merger guidelines, Section 12 explicitly says that we can look at monopsony power even if there is no impact on output or an effect downstream. So to package all of this together, I would say that We look at the impact on consumers, but we also need to remember, of course, that consumers are employees and consumers are sometimes shareholders. And I think it is perhaps an arbitrary and artificial approach to impose these silos. That said, as Dr. Kobayashi mentioned, during the Trump administration for 3 years, we looked long and hard for labor monopsony issues, particularly in hospital mergers and the impact on nurses. And so within the existing analytical framework, without setting up special separate goals for antitrust, we actually do consider all of these issues. What we find, in fact, is that typically when you address the underlying anti-competitive issues of a merger, you resolve both potential harms to consumers and potential harms to labor. But in certain circumstances where that's not the case, the Federal Trade Commission has actually gone directly after harms, monopsony harms, including in our Grifols case that was brought just recently, where there was a merger of human source plasma companies, and the Federal Trade Commission challenged the merger in part because it was going to create monopsony power for blood plasma donors in various cities. In other words, donors of blood were going to get lower fees because of monopsony power. And so the Federal Trade Commission challenged that. And also in the healthcare field, the Federal Trade Commission in a conduct case challenged an agreement between therapist staffing service providers for home health agencies, where they agreed to set prices for therapists, in other words, suppressing wages. And so while I think it is important for us to focus on the economically based consumer welfare standard that we have, it is actually a rich and robust analysis that allows us to look at a variety of different factors, including labor.
And thank you very much, Commissioner. And I appreciate appreciate your input. Given that I've only got a few seconds left, I will yield back, Mr. Chair. Thank you.
The gentlelady yields back. Thank you. And I now recognize the gentlewoman from Georgia, Ms. McBath, for 5 minutes.
Thank you so much, Mr. Chairman. Ms. Payton, I just want to thank you so much for your work as part of our healthcare system. As a cancer survivor, and I'm a 2-time cancer survivor, I know well that behind the many doctors and nurses, there are also dozens of technicians and clerks and administrative assistants and sanitation staff that are making sure that everything always runs smoothly and patients get the care that they need. And you're all frontline workers. So I want to thank you first and foremost for your really hard work. And I find your experience really, really troubling. And so how do the wages and working conditions that you've experienced affect morale amongst you and all of your coworkers?
Working for UPMC, it's kind of one of those two-edged swords. It's good because I actually have a job to go to, but it's bad because it's like my coworkers and I, we can't afford to feed our families when we need to pay all of our bills, and we're scared of the medical debt. UPMC controls the labor market in Pittsburgh, and we need a union to give some of that power back to the workers. They have too much power, in fact, and we need the union to balance that power. That way we'll be able to afford to live comfortably and sustain our families.
Thank you for that. And Mr. Gross, thank you also for being here. Your employer, UPS, is headquartered in my district, which is Georgia's 6th Congressional District. So I'm so pleased to hear of your positive experiences as a UPS employee and also a member of your union. Like hospital staff, like Ms. Payton, you know, you work in an industry where accidents can cause real harm. And you mentioned that your union worked to secure rules that were beneficial to drivers and also promote public safety. Can you expand on that, please?
Thank you, Congresswoman. I mean, UPS puts us through an extensive training program as far as driving and our workers inside the hub. So I think that's, you know, one of the ways that UPS helps keep its workers safe, unionize workers safe. And I don't think that workers that are at Amazon or other part-time non-employees, subcontractors, they don't get the opportunity to have that same training and safety.
And so do you think you would have been able to get these rules that keep you and the public safer if you were bargaining with your employer or by yourself?
I think that the collective bargaining agreement is what levels the playing field with companies, and I think that would definitely allow workers to have an opportunity to have a voice and a say and to be safer on the job.
Thank you. Ms. Payton, I'm running out of time. You testified that you asked your employer to provide you with more PPE and that they told you that this is what you signed up for. Did you feel like you had any recourse whatsoever? Any other actions that you could have taken at that point?
Being that we're not a union at UPMC, it was kind of difficult to even go further in that. We do deserve better PPE and more information because we are putting our lives on the line. We're putting our families' lives on the line. And if we had a union, it would just make our lives essentially better. Like, instead of feeling expendable, we should feel essential, like the essential workers that we are.
And Ms. Payton, you testified, Mr. Gross, your testimony mentioned that Amazon no longer lets drivers like you come into the facility and that you and your fellow drivers think this is about controlling the information that Amazon employees and contractors get. Can you tell us more about what led you to that conclusion? And what would you tell an Amazon driver based upon these experiences that you've had?
I would just say that Amazon doesn't want us talking to those employees because they don't want them to understand the power of our collective bargaining agreement. They don't want them to understand the rights and the wages and the standards that we enjoy in the industry. I don't think they want them to know their worth in the industry. And so I would tell them, that be open-minded and learn and strive to have a collective bargaining agreement.
And I think I'm just about out of time, but thank you so much to each of you for being here today. And thank you so much for being so candid and honest with us. And I yield back the balance of my time.
The gentlelady yields back. I now recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Mr. Gross, do higher prices hurt workers? I noticed in your testimony you said you're married, 4 children. When the price of eggs, bread, milk, gas, when that goes up, does that hurt workers?
Thank you, Congressman. I'm not an economist, but I know the higher prices hurt everyone.
Yeah.
Everyone.
Union workers, non-union workers.
Workers, consumers, everyone. You
got less purchasing power, so even if your wages go up, but in real terms, you got less purchasing power, that's gonna hurt. I mean, my dad was a union worker. I appreciate what you do. My dad worked 30 years for General Motors, International Union of Electrical Workers. My mom cleaned houses. When the price of goods and services goes up, it's tough on families. Isn't that true?
I believe that it's tough on everyone, yes.
How about higher taxes? Democrats are getting ready they're going to try to pass a huge spending bill, $3.5 trillion. They're going to have a bunch of tax increases in there. When your taxes go up, not to mention we got inflation at a 40-year high, so the price of everything you purchase as a family is going up. Now they're going to raise your taxes. Is that going to hurt families? Is that going to hurt workers?
Well, to that, I would like to defer to one of the economists.
But I'm just asking in simple terms, if you have to give more of your hard-earned money to the government in the form of taxes, is that going to be tough on families, especially when you couple with it the fact that we're now at a 40-year high inflation rate?
I understand what you're saying, Congressman, but I don't feel comfortable with that because I'm not an expert.
How about COVID lockdowns? Did that hurt workers when the economy was locked down, typically done by Democrat governors, Democrat mayors? Did that hurt families?
Well, again, Congressman, I appreciate your question, but I'm not qualified to answer that.
I think you're very qualified as someone who head of your union and working hard for your family. How about mandates? We got the state of New York, the chairman's home state. The governor announced last night that they're going to fire healthcare workers because they won't comply with the mandate. Same healthcare workers, by the way, who a year ago were heroes for all the hard work they've done over the last year. Do these kind of mandates, do you think those harm workers, Mr. Gross?
I appreciate your confidence in me, Congressman, but I would have to get back to you with a response on that.
I appreciate your answers, Mr. Gross. Ms. Wilson, let me switch subjects. Excuse me, I'm sorry, Commissioner Wilson. In your written testimony, Commissioner, near the end, you didn't. I don't think you said this in your oral testimony, but in your written testimony, you said new agency leadership. Reading from, I think, one of the last paragraphs, then you give a bunch of examples. New agency leadership, unfortunately, has made meaningful dialogue among commissioners and between the commission and its stakeholders difficult by, and then you list a bunch of things: muzzling staff internally and externally, stifling the flow of agency records and information from staff to commission, there's lack of transparency, given minimal notice to commissioners and the public of sweeping policy change. You go on giving no written explanations of sweeping policy changes until those changes are actually implemented by the Trade Commission, evading meaningful dialogue at the commission level, voting against notice and comment of all other policy, and on it goes. Tell me about this, if you would, Commissioner. What's going on at the FTC?
Thank you, Congressman. I appreciate the opportunity to address this issue. I have served at the Federal Trade Commission on 3 different occasions. This is my 3rd stint at the FTC, and what has always made the Federal Trade Commission special and powerful is its long bipartisan tradition of collegiality, observing norms and traditions, carrying on a rich dialogue at the commission, but also with stakeholders. And as I enumerated in my written submissions with extensive footnotes to other statements that I've made, this observance of norms and traditions that facilitates bipartisanship and a robust and rich dialogue, not just within the commission, but also with all of our stakeholders. And my cat is coming into the picture. Has taken a huge hit under new leadership. And I'd like to note the distinction here. When Acting Chair Slaughter was serving as the chair of the FTC, she continued to observe the norms and traditions that allowed for a bipartisan discussion. It is only with the arrival of Chair Khan that decades of tradition has been thrown out the window to the detriment of our decision-making and consumers.
So this is new. I mean, and we all know, I mean, we function in a body where process matters. Process, impacts policy. If you don't have the right process in place, sometimes you can lead to serious mistakes and serious problems. Should we give the commission more power?
I am very concerned about giving the agency more power under current leadership. A system can only withstand the force that it is designed to channel, and right now I think we are seeing the limits of the force that we can withstand.
Thank you, Mr. Chairman.
The time of the gentleman has expired. Mr. Gross, just so you're not left with a misimpression, the proposal that's before the Congress will actually cut your taxes because you have 4 children, provide lower costs of health care, prescription drugs, paid family leave, and a number of other child care, et cetera. So long as you don't make more than $400,000, you're getting a big, gigantic tax cut. So I didn't want you to leave this hearing worried about a tax increase.
Mr. Chairman.
Based on Mr. Jordan's question. The chair now
That's fake news. I'm
recognizes
just saying
a
that's
gentlelady from Pennsylvania, Ms. Dean, for 5 minutes.
I thank Chairman Cicilline and Chairman Nadler for bringing forth this hearing that centers on complex, nuanced antitrust law, but it centers on the impact, I'm over here, sorry, on everyday Americans. Mr. Gross, I'm from neighboring Pennsylvania. One of my nephews was a proud Teamster for more than a decade with Pepsi. And Pennsylvania, like New Jersey, has been a leading voice in organized labor dating back to the 18th century. And I appreciate your focus, and I won't hit you again on this because you've spoken so well about it, but we often focus on the financial benefits of collective bargaining, higher wages, health insurance, pension contributions, and the like, and we don't talk enough about safety and the hazard implications to workers and to the rest of us on the roads or whatever it happens to be. So thank you for your eloquent testimony on that. So if I could, I'd like to move to Dr. Kalachi. You also talked about workplace safety and workplace conditions. Can you explain from your work how the lack of collective bargaining impacts safety in the day-to-day of the average American worker in other industries?
Sure. So I would imagine, I don't know, I haven't seen the contract, but that Mr. Gross has a health and safety committee at his workplace with joint representation from labor and management to talk over these issues and come to solutions. So, when workers don't have a lot of options for alternative employers because of concentration, And when they're otherwise restrained, and employers are restrained from competing for their jobs by these kinds of contracts we've been talking about, that really limits their bargaining power to be able to gain wages. But even an individual worker, of course, can't get those safety committees without a union. That's a really key element that collective bargaining brings to the table.
And how does that trickle down to the safety for you and for me?
Well, I mean, who's more affected? Who's going to notice a safety hazard first, especially in the healthcare sector, where we have, these externalities, as economists call them, of how pathogens move around from the workplace, to the patients, throughout the community. So that, yeah, absolutely, workers are the first to notice when there's a safety problem. They're the first harmed. So they really need to be empowered, and collective bargaining is the best institution we have to empower workers to bring those concerns to the fore and not be afraid to speak up.
I thank you, and I want to ask you another question in a different area. Are women and people of color more likely to face negative effects of labor monopsony, and why?
Yeah, so we do see. I'm trying to remember if I can, because I want to make sure I'm sticking to the empirical evidence. In terms of certainly non-competes, we have very good evidence through a couple of papers now that non-white and women workers are more harmfully affected by these agreements, because basically it's sort of workers that are more vulnerable with lower bargaining power to begin with are more harmed by these kinds of restraints. And we saw also the Kruger and Ashenfelter study on no poaching agreements and franchising, which showed that those agreements were more common with low wage, high turnover workforces, where the employer was, I've been talking about sort of this notion of baseline monopsony, where basically, almost every employer has some level of control and power over their workers, but this stuff gets supercharged by these agreements, by things like non-competing agreements. So it would stand to reason that if workers are more negatively affected by the evidence shows that for non-compete agreements, that monopsony would also have a more harmful effect.
Thank you. Ms. Payton, I was struck by your testimony, I think as everyone here was. What shines through is your pride in your work, your pride in working hard for an organization, doing worthwhile work, and of course the pride in raising a family. But you are hampered in that 15 years and not making even north of $20 an hour. I wondered, is there anything else you wanted to add to your story that has not come out? And also, are you able to talk to us about how your aspirations for organizing are coming along?
I just want to add that we have been talking to elected officials about this for a long time, and we are hopeful that there will be action. And having a union is definitely the way to go, because UPMC has too much power, and we definitely need the union to give some of that the power back to us workers.
That's terrific. With that, Mr. Chairman, I thank you and I yield back.
The gentlelady yields back. I now recognize the distinguished gentleman from North Carolina, Mr. Bishop.
Thank you, Mr. Chairman. Mr. Gross, I was listening to your description about the Amazon workers, and you said that they, I wrote it down, lower wages, they have to do weekend work, you say they cut corners on safety, you said that there's a lot of pressure. Why do drivers choose to go to work there instead of, say, UPS?
Well, drivers have an opportunity to go straight into driving with Amazon. So with UPS, it's a good place to work. It's a solid place to work. You can raise a family there, and you can pay your bills. You can be a homeowner, follow the American dream. That's what everybody wants. But there's a process that you have to follow. You can't just jump right up into the driver's seat. So a lot of people don't want to take the time to follow the process to get to where they want to go. I think that's really maybe one of the main reasons.
Okay, so do you think that they ought to be able to make a choice like that, or should that choice just not really be available?
I don't really think they're aware of the choice they're making when they originally become an employee for the DSPs. I don't think they really understand. You see Amazon as this big corporation with these boxes with smiley faces, and everyone's happy, and everyone enjoys getting stuff online and shopping, and that's euphoric. But I don't really think they understand what they're getting into. There are certain things about our industry. It's a tough job. It's a worthwhile job, but it's a tough job.
No doubt about it.
And, one One of my coworkers once coined the phrase, we're industrial athletes, And so I think you need to be compensated as such.
Yeah. Okay, sir. Thank you. Ms. Payton, I was struck by something that you said. And it's interesting, the place I come from, Charlotte, North Carolina, it also is the case there that the healthcare system is the largest employer. And I think you said that about UPMC, University of Pittsburgh Medical Center that you work for. And in your testimony, you made the point, and unfortunately, we got the testimony got passed out, I think, to everybody late last night, or at least to me. And so I didn't get to read it all in full. But Ms. Payton, I was struck. You said that, how did you put it? I can't remember exactly, but you were talking about U.S. Steel, and that it's no longer as big an impactful employer as a UPMC that you work for. And that it was unionized and it promised and paid a lot of benefits that people liked and gave a good standard of living. Why do you think that is that U.S. Steel is no longer around, but now the hospital system is the biggest employer rather than a company that's making stuff?
U.S. Steel was big and impactful, but slowly the eds and meds started taking over the city of Pittsburgh. The U.S. Steel Tower now has UPMC at the top of that tower, which goes to show that UPMC is one of the bigger factors in this city.
Ms. Payton, I was just curious, given a lot of the discussion lately, has UPMC ordered employees to take vaccines against COVID?
No, they have not.
Do you think the employer should have the power to impose that decision on you and your fellow employees?
I feel the workers should have a choice, but I also do believe that everyone getting the vaccine will help people stay safe.
Thank you, ma'am. That was very sensible to me. It's interesting, and more broadly into some of the academics that are in the hearing, that seems to me that the Democratic majority fails to reconcile or even apparently to recognize inconsistency in their own policies. Back in 2009, I guess it was, the Congress adopted the Affordable Care Act, also known as Obamacare, and as experts widely recognize, it promoted consolidation among insurance companies. And it's no surprise, really, that then led to consolidation among hospital systems, and that led to consolidation in the ownership of physician practices. And now we're talking about but then hospital consolidation became an enforcement priority for FTC. Isn't much of this, and I think maybe I'll direct this to Professor Posner, isn't much of this the result of inconsistent policy making by the Congress that would tend to promote consolidation and at the same time punish other entities for consolidating?
Well, I think one would have to look at it case by case, but broadly speaking, I don't agree. Congress has a lot of legitimate different policy goals. And in some cases, certain policies will benefit larger companies. But you also need a very strong antitrust law at the same time to prevent excessive consolidation from occurring and from the large companies from abusing their monopoly power.
Thank you, sir. My time's expired, Mr. Chairman.
Time of the gentleman has expired. I now recognize myself for 5 minutes. And before going to my question, I ask unanimous consent to include in the record an article from Open Markets Institute entitled "Eyes Everywhere, Amazon Worker Surveillance Continued," without objection, and also a letter from the chair of the Federal Trade Commission, Lena Khan, dated September 28th, 2021, without objection. Mr. Kalachi, in a letter to the subcommittee, which I just introduced for today's hearing, FTC Chairwoman Lena Khan explains that in recent decades, the agency has largely neglected monopsony concerns and harm to workers. She underscores that this will change and that under her leadership, the agency will scrutinize mergers that lessen competition in labor markets and restraints on worker pay and mobility may violate the law. How do you respond to that? Are there additional steps our antitrust enforcers should take?
So yeah, I fully applaud that effort to take a closer look at competition and to look at coercive contracts. I think in terms of, and I have this in my testimony, a couple of other additional steps would be to look at the effect of buyer power, not just directly on employees, but actually sort of the case that Mr. Gross referenced, where you have buyer power in a supply chain, whether that's Amazon putting the squeeze on the parcel delivery companies, or those kinds of things. We do have evidence that also affects wages. So taking into account those down or upstream effects. And then, dealing with these sort of coercive contracts that try to control and dominate non-employee independent contractors. We have employment law, labor and employment law, because we know that workers are at a disadvantage in the bargain with employers. We have tons of labor laws, labor regulations, because we recognize that. And, companies being able to sort of get that same control, that same, basically have an employment relationship with an Uber driver or with a delivery service partner without incurring, those duties and responsibilities an employer is meant to burden. That is another area, looking at those coercive contracts that are sort of substitutes for employment.
Thank you. Mr. Posner, in your testimony, you explained that you are not optimistic that courts would be receptive to antitrust enforcement to address labor market harms. Why are courts skeptical of labor side antitrust claims, and how do you propose we update the antitrust laws to address harms to labor competition, including non-price effects?
Right, and to emphasize, I think they're skeptical under current law. I'm not arguing that courts don't like workers or anything like that. If law were updated, I think the courts would be more receptive to claims by workers against employers. So what can be done? I think, for starters, updating the laws that regulate mergers, because there's merger litigation in ways that make it clear that rules restricting mergers apply to mergers that affect labor markets. I also think that some of this is technical detail, which I discuss in various places, but the courts have been unreceptive to some of the no poaching cases against franchise because of these kind of silly doctrines that have developed in antitrust law about the difference between vertical and horizontal relationships. There can certainly be technical legislation that would correct that error. And then I think, lastly, I would suggest that for Section 2, the provision of antitrust law that applies to monopolies, I think that could be improved so that certain types of anti-labor practices would be explicitly identified as anti-competitive practices, including the use of non-competes, misclassification, perhaps unfair labor practices. I'm not saying that employers would never have defenses, but I think if courts saw this kind of codification of these ideas, they would be much more receptive to this type of important litigation.
Thank you. Mr. Posner, Commissioner Wilson and Dr. Kobayashi argue that there's not enough evidence on the effect of non-compete agreements on wages and worker mobility to support restrictions on these type of post-employment restrictions. It seems clear to me that non-compete agreements hurt workers, especially low-income workers. What is the effect of these agreements on workers and on consumers?
Well, as I think Professor Kobayashi acknowledged, there's pretty substantial evidence now that non-competes harm lower income workers. The evidence is a little bit more ambiguous for higher income workers, but there's a study that looks at tech workers in Hawaii who are well paid and they were harmed as a result of non-competes. I tend to agree with critics that we probably don't have enough evidence yet to completely abolish non-competes under all circumstances. But my more limited claim is that they should certainly be the subject of antitrust litigation. They are, after all, called covenants not to compete, right? They're rights of trade. And yet there have been a total of 0 cases in the history of this country where people tied up by non-competes have successfully challenged them on antitrust grounds. So whatever the proper rule is, we need to move rapidly in a more restrictive direction.
Thank you. And finally, Ms. Payton and Mr. Gross, I know you both took the day off from work to be with us, and thank you very much for being here. And we often talk about these issues in the abstract. Your testimony helps us recognize what the impact is of an absence of competition in labor markets and how it affects actual people and their lives. So thank you for that. And if there's anything that hasn't been said that you'd like to say in response to a question, I'd like to give you both an opportunity to do that. And I know we're going over a little, but my Republican friend will indulge me. I'll give him a little additional time too.
Thank you, Chairman Cicilline. I would just like to thank you for having us and giving us the opportunity to tell our story. So, thank you.
Yes, and I'd also like to thank you for having me. It's been an honor to be able to share my story.
Well, it's been an honor to hear both of you, of course. I now recognize the gentleman from Wisconsin for 5 minutes and 30 seconds.
Thank you, Mr. Chair. I just wanted to revisit, I know some of this might be a little redundant, but I just wanted to revisit labor and labor markets related to the merger stuff. So, and Ms. Wilson, you can comment, Mr. Kobayashi, again, feel free to chime in. There have been reports regarding FTC sending companies questions that are kind of far outside what you would expect traditional inquiries to be about as a result of the merger investigations. An example is, and I know this can be kind of dismissed as, boy, I've never heard about that before, so I'm trying to raise the profile of it, but FTC staff has inquired about how mergers would affect unionization, as well as some environmental and social issues. This is, it's my understanding, this is a departure from typically what you may see as, what we would consider traditional questions. And some of the other witnesses on the panel have discussed the need to change antitrust laws so that the effects on labor markets are considered. Seems to make sense to me. You both served at the FTC and understand the relationship between the mergers and demand in the labor markets. Can either of you discuss how current antitrust laws and enforcement considerations already account for this issue? Ms. Wilson, would you like to?
Sure. So thank you, and I'm sure that Dr. Kobayashi will also have interesting comments here. So to be clear, the horizontal merger guidelines actually do say right now that monopsony powers should be investigated within the course of merger analysis. And so as Bruce outlined, for at least 3 years under Chairman Simons, we did look for labor monopsony issues in mergers. And so we included specifications in the so-called second request for information of merging parties that sought to analyze the impact of mergers on hiring. But what is happening now, I believe, is going further afield and looking not at what happens for competition for labor, but for other social values. And I disagree with expanding the scope of antitrust beyond competition, which is a load that it is designed to carry. We are not equipped to evaluate the other factors that are now being shoehorned into antitrust analysis.
Thank you. Professor?
Yeah, I want to comment maybe on some of the comments saying that we ought to do something to maybe make thresholds for labor market. If you go back to the Prager and Schmidt article, which is a very good article, I want to make 2 points. One, if you look at what mergers, and they base their concentration numbers on commuting zones, so it's not a product market. It's a commuting zone. You have to go into sort of the extreme quartile, and that's Herfindahl's of about 6,000s with changes to about 2,000 of the mergers that sort of generate the wage stagnation. The other thing that you have to look at is that they test for output effects and the effects of classical monopsony, and they don't find any. It might be that there are bargaining effects, but it's not sort of classical monopsony where you have independent decreases in employment. And then it's limited to skilled workers. But if you were based on the evidence, you would basically put those thresholds at 6,000s, which are like basically a 3-to-2 merger. Those mergers probably will get blocked on product market grounds or on the standard tools that we have. But as I said, and as Commissioner Wilson just reiterated, that we have adjusted our enforcement procedures, including the HSR specs, where we get information to actually look at product market and labor market issues. And I don't know what else you do if you want an evidence-based enforcement of the antitrust laws. We try to get the evidence.
Very good. Thank you. I would yield back.
The gentleman yields back. I would like to now ask unanimous consent to introduce into the record a letter from Greg Nowak, Director of the Brewery and Soft Drink Workers, to Amy Greenberg, Director of Regulations and Rulings Division, Alcohol and Tobacco Tax and Trade Bureau. A statement for the record from the, without objection, a statement for the record from the International Brotherhood of Teamsters, the Service Employees International Union, and the Strategic Organizing Center, without objection, and a statement for the record from the Uniform Law Commission, without objection. I now recognize the gentleman from Oregon, Mr. Bentz, for 5 minutes.
Thank you, Mr. Chair. Commissioner Wilson, and thanks to all the witnesses, an incredibly interesting conversation. Commissioner Wilson, the standard, I'd like to go back to your comments about going beyond competition and trying to apply other standards. It sounds like a kind of a step backwards in what your FTC had been doing in the 50s and 60s. And I just was looking at an article that was commenting on the policies in those years, and someone called it an incoherent mess. And I think maybe that's what you were getting at when you were talking about trying to shoehorn some of these new standards concerning labor into whatever the standard, well, the consumer standard. So could you comment on that just a little more? Because what I'm interested in knowing is if you're asked as the FTC to bring labor standards into this, what are you going to use as the proper measure of success?
You raise a fantastic question. If we introduce additional goals into antitrust enforcement, we are going to have a situation in which the current system, which is predictable, administrable, and credible, is undermined. And so if we are pursuing one goal, which is the preservation of competition, whether it be for the sale of services or for the purchase of services, including labor, that is an assessment that can be done rigorously with evidence, with the assistance of people like Professor Kobayashi, who can crunch the numbers and look at the data. If we introduce additional goals, we are then in a situation where we have to decide which goals to prioritize. And in different circumstances, we may be pushed to prioritize different goals. Antitrust loses its predictability, its credibility, and its administrability. It becomes very subject to politicization and to rent seeking. And I submit to you that is not a good way to run the government.
And just a bit of a follow-up. I was trying to, I know this is an incredible, you guys go into this in great detail and incredible complexity, so forgive the shallowness of this question, but it seems to me that the price concept that you do apply now, consumer benefit standard, would be in conflict with trying to drive up the prices by helping those who are working for these companies get greater job benefits. So how would you balance those two competing goals, if indeed you were charged with this challenge of bringing labor into the conversation?
So you're absolutely right. That is the problem with multiple and potentially competing goals. If the goal of antitrust is to prevent any job loss through merger, then we are going to have difficulty assessing that impact and also at the same time balancing the impact on consumers. And so it is better to focus antitrust on a single goal, competition, which also includes the wages that labor is being paid. So if there is monopsony power, if a merger is going to involve, say, the only 2 hospitals in a city that will suppress wages, then we step in and we prevent that merger, which benefits both consumers and the nurses and others who work for the hospitals. Let me just add to what Professor Kobayashi said about hospital mergers. he indicated that there was significant focus on figuring out why the FTC and DOJ were losing so many hospital mergers. And I had the privilege of serving as chief of staff to Tim Muris when he launched the hospital merger retrospective to figure out why. And the economists and the lawyers at the Federal Trade Commission studied the issue, figured out how to try cases in a way that launched us on many, many, many wins. Over the last 17 years, we've had only one loss when we challenge a hospital merger. The problem with hospital mergers is so many are occurring below the HSR filing thresholds. And so we are very interested in identifying hospital mergers that do not need to be notified to the Federal Trade Commission and assessing whether those are causing anti-competitive effects, including suppressing wages for nurses and physicians and others who work for those hospitals.
Thank you, Commissioner. Mr. Chair, I yield back.
The gentleman yields back. I now recognize the gentleman from Utah, Mr. Owens, for 5 minutes.
Thank you, Mr. Chairman. And I thank you all the witnesses for joining us today. I, like so many of my colleagues here, am deeply concerned by the Biden administration's general approach to regulations and economic policies, and in particular the impact that those policies are having on businesses and workers back in my home district. I also share concerns expressed today on both sides of the aisle regarding monopoly organizations like Amazon. Mr. Gross and I have different backgrounds. He is with the union, mine is a small business owner. We probably would respectfully agree to disagree on some of the solutions, how to get there, but we both emphatically have the same end game, that is protection of the small business, the small middle class. Protection of the middle class. Only through the free market competition can that happen. As we see with the big tech and other monopolies across many industries, there's absolutely no tolerance for small business innovation, service, and the drive to reach the middle class. I'm thankful for the leadership of the ranking member, Mr. Buck, and for taking on the big tech monopolies and others that we are addressing as we've come to become aware of in 2020. Commissioner Wilson, on page 5 of your written testimony, you mentioned how the American economy is struggling to recover from COVID-19 pandemic. You also suggested adopting a highly interventionist competition policy at this time will harm everyone, including American workers. I'm worried about the Biden administration's general approach to regulations and economic policies, and particularly the impact on those, again, workers and businesses from my home district. Today in this hearing, we're not simply talking about proposals that would affect a particular sector or industry. We're talking about broad policy changes that would even override some state laws. Do you have any reactions to these concerns, especially as they relate to labor markets?
I completely agree with your concerns about regulation and the cost that those impose and the chilling effect that they have on innovation. I would note, with respect to emerging from the economic devastation of COVID, one step that the Federal Trade Commission has taken is throwing out the vertical merger guidelines with essentially no notice, no opportunity for input. And its expressed intent to take a much stronger enforcement approach for vertical mergers. And here's the problem. Supply chain vulnerabilities were exposed during COVID, and to shore up the supply chain, many companies are seeking to bring the vulnerable aspects of the supply chain in-house so that they have control. Now, we have a situation in which there's an expressed intent to enforce vertical merger law much more aggressively, and at the same time, there's no guidance. People don't understand what the new policy is with respect to vertical mergers, and we have been told by the majority at the commission that there will be onerous penalties for bringing what they perceive as anti-competitive deals to our doorstep. And so we have removed guidance from the business community, which is seeking to emerge from the COVID economic devastation, but we're going to double the penalties if they cross the line, but they don't know where the line is. So it's problematic.
Can you describe the role of state attorney generals in challenging unlawful no-poach agreements and whether they have been successful in that role?
I think the state AGs have been very successful. The Washington State AG has, I believe, brought cases that have affected close to 200,000 locations across the country, not just in Washington. And this goes back to the point I made in my written testimony in particular, that there is a very rich, robust set of state law and common law that governs non-competes and no-poach agreements. The state AGs are active. My understanding is that in Ms. Payton's state, Pennsylvania is looking to pass a law on non-competes. And these state legislatures are very responsive to the needs of their constituents and the facts on the ground, and they are very active.
Thank you so much. I yield back.
The gentleman yields back. This concludes our hearing. I think we've covered everyone. Just a reminder that members will have 5 legislative days to submit additional materials for the record. I want to again thank our witnesses for their really helpful testimony that I think will allow this committee to move forward in a very productive way to make certain we can really promote competition in labor markets that will benefit American workers. And thank you again to everyone for their testimony. And with this, the hearing is now concluded.